us a few minutes so we can make this decision? Because it might save a bunch of time. So today then, are you just planning on finishing this and calling that woman? Well, if you tell her, it might result in saving some time. Oh yeah, we're not necessarily complaining. I just wanted to see what I'm doing. That's all.
You want the other day?
Yeah, in just a second. So, is there a picture of the trash can with the shoes?
I don't remember seeing that, but it could be on.
I thought at one point I saw that somewhere.
Could have been in the fire marshal photos. Because there's 3 different agencies that are taking photos of the same thing.
Gotcha.
And it's extremely frustrating.
I understand.
So I think we only did ATV ones.
I hear you. I'm not doubting that's where they're on. I just wanted to know.
If you want to stipulate to that, those too. Those photos too.
Can I see the other one? And this is on the 26th of May.
Yes. And so he made a point, he was like, are there fire marshal and fire department photos too? I think there are.
Yeah, but the
Same
fire marshal's come and gone, right?
Yeah.
So, I mean, I guess I would say these are, I'd agree, probably. I'm just looking through. But I don't want to do one of the fire marshal ones now because, like, right now I could, Detective Looney, you were here for this, right? Well, let's just say we have a photograph here that we think is important. I'm not saying we do, but let's say we do. If I ask him, boss, does this fairly and accurately depict the picture? He says, well, I don't know.
But you were in the house though, right? He's gonna say, he's gonna recognize all this. He went through all the rooms and everything.
Yeah, I just don't want to get to a point where he's saying I don't recognize
He's not, if we'll stipulate.
All right.
If that happens. Right, I mean, we're not,
I know.
unless there's some contention of the hash value of these photos.
What is this? Is that the TV?
Yes. I think it's a stand. What's under the stand.
I don't know. Is there a problem with it? Oh. Are you going to be in the way? No, you're not in the way. Detective Looney, you were in both 1374 and 1370 at some point? Yes. Okay. For this guy? Yeah. Oh, okay. Scott, you agree we're good?
I think we're good.
All right, we'll do it. Either party could talk about either of those, the May 26th or the May 18th.
However, this is what Quincy and I are going to decide whether we're even going to call.
Alrighty.
And if we do, it'll probably be tomorrow, and we probably will need a Ring Central link, so we'll let you know by the end of the day.
Alrighty.
Secondly, I think we do have an agreement in regards to Detective Soroki's testimony. He simply was a crime scene unit detective who went to both 1370 and 1374 Hillcrest and took photographs during 2 search warrants. One occurred on May 18th of 2017. The other one took place on May 26th of 2017. They're in PowerPoint format and marked as States Exhibits 128 and I think 127. I think we have a stipulation to those photographs coming into evidence with the additional stipulation that if additional photos from those 2 search warrants are located on the discs that contain all of the photographs, that those photographs also will come into evidence as they're authentic and fairly and accurately depict the scenes on the 26th and the 18th. The difference is that all of the photographs on the discs are not in the PowerPoints that I have prepared. So the point is that they find a photograph.
Oh, that they want to use.
Yeah,
Okay.
that comes into it.
Okay.
And then that, based on that, it's going to dramatically, after Mr. Barker testifies, we have one lay witness that will testify, and then we've already done for the day.
Is that Glenda Gunn?
Yes.
And who is she?
She's a neighbor.
Okay, so where are the AT&T and Verizon people?
Tomorrow afternoon,
Okay.
they're scheduled for, to testify via Ring Central.
Okay. And then Troy Looney and Dr. Kohler.
Yes.
Okay.
Dr. Cole will be right at 9.
So when Mr. Barkhurst is done, then you'll have this Glenda Gunn.
Yes.
I called her Gloria, but it's Glenda.
Glenda.
Okay. Yes. Okay.
Judge, the stipulation's correct with this caveat, I think. The photographs that we're stipulating to would be the photographs taken by the Akron Police Department on May 18th and May 26th. There were other agencies that took, including the fire marshal, took photographs, Judge, that have not been introduced in this trial. They are not available at this point because they were testified to testify. So we're stipulating the Akron ones because if Detective Looney gets on the stand, he was there.
Right.
He can say yes,
Okay.
that fairly and accurately depicts the scene. So that's, you guys agree that's what we're talking about? Okay.
With one clarification of that, regarding the search warrant in these 2 houses, that they have already testified about photographs that this fire marshal took of the fires and things of that
Right.
nature. We're just limited this to 1370 and 1374 during the search warrants on those 2
Yes,
cases.
yeah, that's what I'm saying.
Yep.
Alrighty.
So we agree to that.
All right.
Judge, scheduling issue for me, it's been scheduled for quite a long time. Tomorrow at 12:30, by video, I have a federal sentencing.
I think I knew this.
Yeah, it was originally set at noon on the 16th. The judge moved it to the 14th on his own to noon at 12:30. So I would, Judge, I can do it by video from here on my phone, but I would need to be not in trial at 12:15.
How long do those normally take?
Judge, I can't imagine that we wouldn't, Judge Wynn usually moves fast. So I would say that we, at the latest, Judge, I would be available at 1:30, but I think I'll be available even before then.
Okay. I'll just make sure that we stop between.
Well, it's at lunchtime.
You know, in other words, if you go at 12:15, prepare for 12:30, if you go to 1:30, then you're going to need a half hour for yourself.
No, and I don't think it's even going to take enough.
Eat while the sentencing's going on. I'm sure he probably won't have a problem with that whatsoever.
And wear your shorts too. I'll eat for you.
All right. Yeah. So we'll make sure tomorrow at 12:15 we'll break and give you, we'll give them an extended amount of time so that you can get that all covered.
Okay, thank you.
And then with regards to your request, Mr. Masich is going to call Portage County to find out what they need from me to have him transported here for Wednesday.
All right, and what we learned, Judge, I learned actually last week was I ran into Connie Lewandowski at our son's football game, was that Mr. Boggs, instead of going to trial, has pled and been sentenced on his new case.
Okay.
Connie told me that.
Is he being held there still, though?
She thought he still was.
Oh,
So,
I hope so. All right, call immediately then.
yeah.
And who's the sentencing judge?
Pittman.
All right, and also then call Judge Pittman's court and tell her that if he is due to be transferred, if she'll hold that until after Wednesday.
Yeah, and like I said, Judge, we don't even know for sure we're gonna call him.
I understand that, but the last thing I want to do is have to go down to somewhere down at Lorraine to get him through his processing. So if
Appreciate
he's
it.
there, I want to get to the judge and get him held there till you make the decision whether he's going to testify or not.
And then lastly, Judge,
I guess whether he decides to testify or not is probably a better question.
sure, he might take the fifth. Judge, lastly, I'll call him a cellmate, he was at least in his pod, but that person that revealed to the deputies, not to set the presence of the jury, that Mr. Boggs had confessed to him, that person has been located by us and served with a subpoena. Mr. Riley has been in contact with him. Mr. Riley's secretary talked to him yesterday, Scott? Yesterday, and we had him subpoenaed for today, is that right? Tomorrow, and we told him Wednesday, and he said, well, I don't know if I'm coming or not, basically, I'm paraphrasing.
We love that.
So he is under subpoena, and we could bring in Scott's secretary to verify that she spoke with him, and he knows he's supposed to be here on Wednesday.
Alrighty. Well, I guess we'll cross that bridge when we come to it, and if I issue a material witness warrant and those types of things, we'll go from there.
Right.
Well, and Judge, we're obviously objecting to that because it's hearsay, so.
Well, I'm not saying he can testify, I'm just saying he's been subpoenaed to be in court, and if he doesn't show up, we'll go that route first.
In general, I don't believe it would be hearsay to say I had a conversation with Mr. Boggs. Based on that, I contacted a deputy to tell the deputy what he told me.
And how's that relevant?
I think it's relevant.
What if he says, I didn't eat well today?
Well, you can make that argument, but it's.
Well, guess what? All right, again, you two. I get to make that decision as to whether it is or isn't admissible, and we'll cross that bridge when we get to. But if we, right, I understand. So we're ready to send somebody out for him if need be.
Yes, ma'am.
I was going to say something in response to that, but now I don't remember what it was. So I guess it'll come back to me at a later date. All right, anything further?
No, Your Honor.
All right. So do you want me? What exhibit number is that you're stipulating to then?
127.
Alrighty.
And for the record, it's search warrant photographs taken by the Akron Police Department on May 18th of 2017. And then also Exhibit 128, which are photographs, search warrant photographs taken on May 26, 2017 by the Akron Police Department.
The first date was May 20 what? I'm sorry.
May 18th.
18th, okay.
Second one's May
All right,
26th.
and this was stipulated. All right.
127, 128.
Yeah. So what?
127 is May 16th,
May 18th,
May 18th, and the other one's May
26. Can someone tell me what 122 is?
I don't have 21.
Okay, glad to know it. I'm not sleeping on the job. And 134, is that open too?
134 is open also.
Okay, good. All right.
And
And
Judge, I also have,
137.
The video presentation.
Oh, we haven't gotten it yet. That's fine.
Well, no, it's a video. Yes, no, you're not.
I don't have 106 either. Does anybody have 106?
Yes, it's Molly Jordan's January 30th, 2017 report.
What were the other numbers, Judge?
That's right. I show 122, which you're going to mark soon. 134, 137.
Yeah, and
Okay.
those are yet to come.
Okay. All right. I'm just making sure I didn't miss something. All right. Anything else?
No, Judge.
Bring the jury.
All right, please.
County Court of Common Pleas is again in session. The Honorable Christine Tracy presiding.
Thank you. You may be seated. All right, Mr. D'Angelo, you may proceed with Mr. Barker's testimony. Mr. Barker, you're still under oath.
Thank you very much, Your Honor. Mr. Barkhurst, I'm going to show you an exhibit that's marked for identification purposes. It states Exhibit 122 on your screen. I'm pausing it right there. Can you tell the jury what this is, states Exhibit 122?
This is the video presentation I made for the 2017 fire.
You viewed this prior to coming to court today?
Yes,
fair and accurate depiction of the video presentation that you made.
yes.
Your Honor, we were going to ask if you could dim the lights.
Courtroom lights?
Yes.
I say that. Come right behind you. You're fine. No.
Thank you very much.
That, because I don't, if I shut the other ones off, it'll be really dark. Like pitch black.
Conversation recorded on May 15, 2017 at 2:46 on Channel 5.
Akron 911, relocation of your emergency. There's a house on fire on, I'm not sure what the address is. It's, FLCC? Yeah. Is it by name, Central Line, Southwest, or East? It's by Heights, 365 feet. Can you see it from your house? Yeah. How high are the flames? They're pretty high. You know, how far away are you from it? Right the street on the Hillcrest. Okay, do you have anybody there to occupy? There are people that live there, yes. Does anybody outside? I didn't see anybody. How far are you down the street? I don't know, a couple, I don't know. I'm not good with it, stuff like that. Do you have any yelling or screaming, or is anybody? I don't tell anybody to get out of the house. I don't hear anything. How about told the LTC? Yes. Okay, we're going to find it now. Thanks. All right.
End of recording. Conversation recorded on May 15, 2017 at 2:49 on Channel 6.
Hello? Hi, this is Akron 911. You got a call from your number?
Yes, it's a house on fire. I smell the gas. I mean, the smoke from a house on Gilford Street.
Okay, what's the address of the fire?
I don't know, it's almost gone, the whole house is almost burnt up. I just looked out my window from the corner, I walked to the corner, the house is on fire, it's almost gone.
Okay. It's almost burned,
The
right?
main street is Fultv, off the Hillcrest. And the house is almost gone, I'm at the corner, I stay on Hillcrest, I'm at the corner, the house is almost gone.
Okay, so you're saying it's on Fultz?
Yes, it's off the Hillcrest corner.
Hillcrest Corner? Okay.
And this house is almost gone. It's about to be hitting the house next door to it, and I don't even know if anybody's staying in the house that's next door to it. It's a car in front of the house that's on fire. But I don't see nobody outside on the street at all. I don't even see nobody near this shit.
Okay, we can get another call, well,
Farther down.
okay, there's a car at the house that's on fire?
Yeah, it's a car sitting right in front of it.
Okay, and you don't see any people?
No, I don't see no one.
What is your
house
house?
is almost. My name is Shakira Richardson. I stay at 1383 Hillcrest.
Wait. Richard.
It's about to start hitting the house next door to it, and I don't even know if nobody's in the house.
Okay, what is your address again?
Mine is 1383 Hillcrest.
Okay.
I heard all the booming from the back. I thought somebody, it was something like it was on the side of my house, so I'm just out the window and seeing the smoke, so I walked down to the corner. That house is gone. And this brother start touching the house next door to it.
Okay, well, fire company is on its way.
Yeah, I hear them, but it don't sound like they closed at all.
Okay.
And they had, I think that sounds, I don't know if that sounds, but they had a party the other day or not, but somebody had a party on this street earlier and today. See, it's getting bad.
Okay,
The ambulance just had to back up. And they're the first ones here.
who had backup?
The ambulance just had to back up.
Oh, okay.
It just did another big old boom.
So like an
The
explosion?
ambulance here. Yeah. It just keeps on popping like it's an explosion. That's what woke me up.
Okay. Alright, yeah, engine 4 should be there also. Did you find it?
Yeah, they're pulling up now.
Okay.
Yeah, they're pulling up
Alright,
now.
yeah, we have a whole bunch coming.
Okay, thank you.
You're welcome, thanks for calling.
Right. End of recording.
Okay. Mr. Barkhurst, there was one section where in the video presentation where it mentioned video playback issues. Do you recall that portion of your video presentation?
Yes,
I believe it was for 2 seconds that you had noted that. Do you recall that?
yes.
What did you mean by that when you put it in the video presentation, and can you further explain that?
Sure. Originally, when I was looking at it, there was some, I didn't see the video playback correctly. I know that there was times where there was a time where I made an attempt to see if I could get some of that video to play back. And when I did that, there were issues playing it back because I didn't do it perfectly. Using the method, I can see some of the cameras and the video played scrambled. Is the best way to describe it. However, I did check, and I did find that there was video of it playing correctly.
For those 2 seconds?
Yes.
And when you watched those 2 seconds, did you notice anything of any relevant activity?
No.
Okay. Now, Mr. Barkhurst, were you asked to compile or work on some side-by-side comparisons for both the 2016 and 2017 fires?
I would describe them as side-by-sides.
Okay, and what are side-by-sides?
Side-by-side video.
Okay, and what do they depict?
Of a known individual and an unknown individual.
And what are they doing in the videos?
And may I add that there's one video clip at the time when I made it, there is an unknown and an unknown.
Okay, and what are they doing in those side-by-side comparisons?
Walking.
Okay. I'm going to show you what's been previously marked for identification purposes as State's Exhibit 134, and I'm not going to play this video for you, but I would like you to at least look at the title slide and see if you can identify it, okay? Mr. Barkhurst, do you recognize that?
Yes.
Can you tell the jury what this is?
It's a side-by-side video that I had produced.
Okay, fair and accurate. Have you watched this prior to coming to court?
Yes.
Fair and accurate depiction of a side-by-side video that you produced.
Yes.
Okay.
What number is that? I'm sorry.
134, Judge. Next, I'm going to show you another side-by-side video marked for identification purposes as State's Exhibit 139. Mr. Barkhurst, do you see this slide here, 139?
Yes.
Tell the jury what this is.
That is side-by-side walking video clips.
Okay, then you prepared this?
Yes.
Fair and accurate depiction of a side-by-side walking clip that you prepared.
Yes.
Judge, I'm just gonna check, the only thing he's looking at is the titles page, right?
Yeah, I do believe in, did you, on State's Exhibit 139, had you viewed that prior to coming into court today?
Yes.
Fair and accurate depiction of what you completed?
Yes.
Same with 134.
4.
Did you view that before coming to court today?
Where is that one?
134, did you view one, I think he already testified to this, Judge.
All right, I missed the part about
Yeah.
previewing it prior.
In 134, this was the first one that we looked at, Mr. Barkhurst. Have you viewed this prior to coming to court today?
Yes.
Fair and accurate depiction of the side-by-side walking clip that you prepared.
Yes.
Okay, finally, I'm going to draw your attention to State's Exhibit 137. Mr. Barkhurst, can you tell us what this slide is, or what State's Exhibit 137 is?
Side-by-side.
Okay. Walking clip that you prepared?
Yes.
Have you observed this walking clip prior to coming into court today?
Yes.
Fair and accurate depiction of another side-by-side walking clip that you prepared?
Yes.
any other questions, Judge? Thank you.
Mr. Riley?
We don't have any further questions, Your Honor.
All right, Mr. Barker, you're excused. Thank you very much.
Can we come to side room?
You may. Oh. Anyways, pass your, you know what I'm talking about, exhibits 23 to, thank you. Can you pass them all down to the end? We're gonna go ahead and take just a short 10-minute break. It's 2:10. You'll be back in the jury room at 2:20. Remember the admonition I've previously given you concerning your conduct. It's important that you not talk about the case amongst yourselves or with anyone else. Don't let anyone else talk about it in your presence. And again, do not form or express an opinion until the case has finally been submitted to you. Leave your pads upside down on your seats, and we will see you back here at 2:20. Go, you could, yeah, just go ahead and open the door.
County Court of Common Pleas is again in session. The Honorable Christine Curtis presiding.
Thank you. You may be seated. Ma'am, if you'll remain standing for me, raise your right hand, please. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Go ahead and have a seat. And then I'll just ask that you keep your voice up and speak into the microphone, please. You may proceed.
Thank you very much, Your Honor. Ma'am, can you please state your full name and spell your last name for the record, please?
Glenda, V. Gunn, G like George, U-N-N.
Ms. Gunn, can you tell the jury where you live?
I live at 710 Fulton Street in Akron.
Okay. And looking at State's Exhibit number 14 there next to you, do you see your residence on that map there?
I do.
Okay. And using this pointer here, you press this button. There's a red dot. Can you please point on State's Exhibit number 14 and show the jury where your house is? How long have you lived there?
Since 2007.
Where are you employed?
Actually, I'm retired, but I do work for my church.
What church is that?
Jerusalem Missionary Baptist Church in Akron, Ohio.
What do you do?
1225 Vernon Odom Boulevard.
Okay. What do you do for them?
I am the administrative assistant.
Okay. Now, Ms. Gunn, were you aware or are you aware of that occurred in your neighborhood in April of 2016 and May of 2017?
Yes.
Regarding the first fire that occurred on April 18th of 2016, can you tell the jury how you were made aware of that fire?
My daughter came into my room screaming. My blinds was red, the house is on fire, and she ran down the steps with her cell phone, and I came behind her as fast as I could, and we got out there. She was dialing 911, but the front of the house was engulfed in flames.
Okay. And so did you initially think it was your house?
No, I knew it wasn't my house, but
Yeah.
she said that she heard something popping. I think it was the electrical, something on the electrical pole that woke her. Blinds were red, and so she looked out, and that's when she saw the fire.
Where was that house located, if you could point to it on the map?
It was,
Okay. Right in that empty lot there.
mm,
Did you know the man and woman who died in that fire?
I knew the man. I had met him before, but I did not know the woman.
Okay. And his name was Lindell Lewis, is that fair?
Yes.
Okay. And can you tell the jury what you would observe go on at that house prior to the fire? What kind of things would they do there?
Well, he had a lot of people that's, always on the porch. Some of them I know were homeless because I had seen them begging, with the signs at the expressway exit. I've seen a couple of them do that. And one of the people that I had seen over there before came to our church, and our church helped her and bought her clothes and, toiletries and stuff, and tried to help her to get straightened out.
Now I'd like to draw your attention to May 15th of 2017. Do you recall that time period?
Yeah, if you help me.
Yeah, that was the day of the second fire that occurred on your street.
Oh, okay, the second fire.
Okay. How did you become aware that that house was on fire or that that fire occurred?
Again, my daughter came into my room, and it was at dawn, and she was saying, Mom, she said, I think we have a fire on our street. And I went over to the side of my bedroom window that faces in that direction, and I saw two fire trucks outside, and one guy that seemed to be spraying the house down, but I did not see it engulfed in flames or anything like that.
And where was that house? Could you just point to it? Okay. And that's on State's Exhibit 14. You're referencing that in that fire. So the fire department was already there when you first noticed it.
Yeah, so I said, well, I didn't see any ambulances out there or anything like that. I said, probably everybody is okay. And she went back into her room and I tried to go back to bed, but maybe about a half hour later, my phone started ringing. People were calling to ask me if I was okay.
Family members or friends and family?
One of my friends was all the way in California when she called me.
Oh,
But
wow.
she has some kind of acrid feed. She's a homegrown girl.
Did you know any of the family members that lived there at that house?
Not really, no.
Okay. Do you know if they had any pets?
Yes.
Tell the jury about that.
They had a dog there that my dog kept breaking out of our enclosure in the backyard to go visit.
Did their dog get out a lot, or?
Their dog was always out. I was trying to keep my dog in. My yard is totally fenced in. So the little rascal figured out how to dig up under the fence. And as much as we tried to pin him into the yard, he would always find a way to dig himself out, and then you see him following the other dog up the street. So,
Ms. Gunn, did you know the defendant in this case, Stanley Ford?
yeah, I was acquainted with him.
Okay, and when did you first meet him?
Actually, Mr. Ford was always very friendly, so whenever he would be outside, if I'm going in or out of my house, he'd always throw his hand up or wave, you know, and I'd see him in the grocery store. He, you know, sometimes him with his family down at the Acme on East Avenue.
Would you speak with him regularly?
If I saw him, I would speak to him, yeah.
Okay.
'Cause I just looked at him as just a family man, you know, trying to raise his family.
Sure. And Ms. Gunn, I'd like to draw your attention to a day in May of 2017. This is going to be after the second fire had occurred at 693 Fultz. Do you remember a time period where there was a bunch of commotion going on outside of your house?
It was after we found out that all the people had died in that fire. And I had gotten sick, actually. I was in my bed. I had a slight fever. I knew I did, and I just didn't feel good. But
What did you notice going on outside?
Well, I kept hearing helicopters roaring in the sky, which is not unusual. Usually, if you hear a helicopter, it's passing through on its way to one of the hospitals. But this day, the noise just kept going and going and going. So I got up and threw something on to go outside and see what was going on.
What did you see when you went outside?
Every news truck, that you know, all the local news, Channel 3, Channel 5, Channel 8, Channel 19, investigator cars, police cars, and all up and down Fultz Street had cars, and it looked like going down Hillcrest had cars, and a lot of people outside.
You see police officers?
Yes.
At some point, did you see the defendant, Stanley Ford?
Yes, I saw Stanley was standing at the end of my driveway when I came out of my house.
Can you point on your map where he was standing? Okay. Who was he standing there with?
A group of people. I assumed some of them may have been relatives, but I really didn't know any of them.
Did he say anything to you?
I said something to him.
What did you say to him?
I said, "What's going on out here?"
What did he say?
He said something to the effect, they think I had something to do with this fire down the street. I don't know anything about those people.
Okay. And did he say anything about a camera being on his house?
Well, when he said that, I asked him, well, why did they think that? And he told me that they thought that because the neighbor had a camera on that saw him going into the house around 2:30 in the morning. He said, I can go in my house whenever I get ready. Something to that effect. And then I turned around and went back in my house.
He said the camera had observed him going in the house at 2:30 in the morning.
Around 2:30 in the morning, yeah.
Ms. Gunn, do you see the person in the courtroom who made that statement to you?
Yes.
Can you please point to him and describe what he's wearing for the record, please? You can point with your finger, you don't have to point with that.
He's got on this plaid blue shirt and a face mask.
Your Honor, may the record reflect that the witness is identified as the defendant.
The record will so reflect.
Do you know Mr. Ford's sister?
No.
Okay. Was there someone there with Mr. Ford when he was making that statement to you?
Yeah, and I assumed there was a family member, maybe a sister.
Why did you assume that?
Because after he said that, she called him over to herself. As I was turning to walk away, she was calling him
Okay.
to come here.
Telling him to come over here.
Mm-hmm.
What did he say to that person?
I don't really recall if he said anything to her. I think that I do recall, though, that he did just go over there to her.
Okay. I don't have any other questions.
Thank you. Mr. Gordon?
Thank you, Judge. Good afternoon, ma'am.
Good afternoon.
My name is Joe Gorman, and this is Scott Riley, and together we represent Mr. Ford. I don't have many questions for you, but if you don't understand my question, just let me know and I'll rephrase it so you do. Is that fair?
Fair.
Is it Miss or Mrs. Gunn?
Miss.
Miss. Miss Gunn, that day that you spoke with Mr. Ford on at your driveway, that was after the fire, correct?
Yes.
Was that was the same day that they were actually searching Mr. Ford's house?
I don't know what they were doing with his house. I had heard about them searching, but I didn't pay attention to any of that until after he told me why they thought he did the fire.
Okay, so he was telling you he's telling you that they, meaning the police, thought he did it.
Yeah.
Okay, and this wasn't the morning right after the fire. This was the next day, probably.
I'm not sure.
Okay, you don't remember.
No.
Okay, but he's telling you what the police are accusing him of and why they're accusing him, correct?
Objection.
Hold on a second. Overruled. You may answer.
Would you repeat the question?
Your understanding was he was telling you why the police were accusing him, correct?
Yes.
Okay.
When he said they think, I assumed he meant the police.
Say that again, ma'am?
When he said they think,
Okay.
I assumed he meant the police.
Okay. And do you know whether or not he had already talked to this man, Detective Looney, prior to making that statement to you?
No, I don't know.
Okay. Just 1 second, Judge. Ma'am, thank you for answering my questions. I don't have any more at the moment.
Mr. D'Angelo? You're almost done, ma'am.
Ms. Gunn, just a couple questions. You testified that the defendant said they think I had something to do with the fire down the street.
Yes.
Okay. And then he later said, when in response to your question, why do you think that? You asked him that,
I said,
correct?
why do they think that? Yeah.
And he responded, this guy over here has a camera on my house, right?
Yeah, he said his camera saw him going into his house at 2:30 in the morning.
Hold on a second. Overruled, though. I noted, but overruled. Go ahead. Finish your answer.
Go ahead.
Yeah, he was saying that the camera had captured him going into his house at 2:30 in the morning, which I really never saw that camera there before until he pointed it out to me.
And what did he say about going into his house then after that?
could go in and out of his house at, whenever he wants to, or something to that effect.
I have no other questions.
Ma'am, but your understanding is he's telling you why the police are accusing him. The police are telling him they have him on camera, correct?
That's correct.
Well, yeah, as to the characterization, that's what you assumed he meant, is that correct?
Yes,
All
ma'am.
right.
No further questions.
All right, ma'am, you're done. You can step down, thank you. You can go right out this door, thank you so much.
You're welcome.
Do you have any other witnesses?
All right, ladies and gentlemen, we're finished a little early today. I have 2:45. So we're going to break for the day. I'm going to remind you the admonition I've given you at all breaks and at the end of each day. It's important that you be fair and attentive throughout this trial. Do not discuss this case amongst yourselves or with anyone else. This includes family, friends, and the media. You must not post or read anything about this case, whether on the internet or through any broadcast or media. That includes any laptop and or including your cell phones. Any such discussion, if discovered, could lead to a mistrial and again severe. And I have executed an order to have Mr. Boggs transported from the reception center, and I believe that's at Orient, which is south of Columbus. Is where they're telling me he's being housed at the moment. So the earliest that deputies can pick him up will be Wednesday morning, and Mr. Mason is working those details out with Mr. Pekarski. All right. So it appears that the state may have 2, possibly 3 witnesses, plus the 2 Ring Central for tomorrow. Is that right?
Yes.
All right. So there's a likelihood that you could be resting your case tomorrow?
Yes.
All right. I mean, it's fluid, I get that. I'm just for scheduling purposes. All right. So Wednesday, there's a good chance, I don't know, it's a 2-hour drive. So even if they leave at 7, they're not going to be back here till 9 and 11 in the morning. So I'm not sure if you have other witnesses, but I want to talk about these other witnesses because, I want to understand, based on the conversations that, you and Mr. Lacunzi have been having somewhat on the breaks, and what you expect these witnesses to testify to. I want to have a record of that, and then we'll go from there. And then I'll make my decision. So I know that you have 2 deputies subpoenaed from Portage County, and I don't know what the nature of their testimony is going to be.
Judge, I can, I guess proper what we anticipate. Oh, I'm sorry. We told. I can proper judge what I guess I anticipate the testimony to be. Why don't I start out by doing this, Judge?
Sure.
It's brief, but there is a report that's been provided through discovery from Corrections Officer Karen Kraus, Portage County Justice Center, who authored this, and I think it would give the court some insight into where we were going. So you already know, Judge, from the record or from opening statement from the prosecution, they stood up and they told the jury that Patrick Boggs was a suspect in the second fire on May 17th because he had started his wife Angela Boggs back years prior on fire because and all the information that we're getting, judges, and all the police reports is because he's a racist and he did not like the fact that she was dating a black man. So that's just the background of Mr. Boggs. He went to prison, I think, for 10 or 12 years for pouring or igniting her with lighter fluid and trying to burn her to death, I think. He went to prison for that. So that's throughout the discovery, Judge, we learn of him. He's listed as suspect number 2 in Detective Looney's ROI, his report of investigation. And with that said, Judge, what they did was, as you already heard, they went out, they arrested him on pursuant to, I believe, his parole, and put him in jail, put him in custody, brought him to the 6th floor and interviewed him. And of course, Judge, he denied any participation. They also subsequently did a search warrant, and he was in the Portage County Jail. If I'm not mistaken, Judge, it was because of some parole violation, but it was really because he was a suspect in this case. So while he's in the Portage County Jail on May 21st,
Of what year?
of 2017,
Okay.
after all that had happened, after he'd been interviewed, and actually the same day he had been interviewed, Judge. It says on May 21st, 2017, at roughly 14:35 hours, 2:35 in the afternoon, inmate Selby pressed his intercom and requested to speak with an officer. At this time, he would not state what he wanted, instead requested to speak with me face to face. I entered CM1, which I'm assuming is a cell block, and tried speaking to him through the food pass of his cell door, but he was speaking so quietly that I simply couldn't hear him to understand his request. He motioned to cell 126 a couple of times, however, and I gather that it had something to do with inmate Patrick Don Tawney to open cell 125 and instructed inmate Selby to follow me to the officer desk. He followed me, and when we reached the desk, I again asked him what was going on. It was at this time that he informed me that inmate Boggs had just confessed to him the murder of the family in Akron. He stated that inmate Boggs had told him he started the fire using barbecue grill on the porch of the house and made further comments of throwing hot coals into a plastic garbage bag. Inmate Selby appeared a little shaken and stated one of those kids was his, meaning Mr. Boggs's kid. I'm adding that, Judge. How can someone do that, question mark, unquote, unquote. He further stated that when inmate Boggs made these statements, he also stated that he did it out of anger over his ex-wife having a relationship with a black man. Having witnessed inmate Boggs sitting outside of inmate Selby's door for a little while throughout the day talking to him, so the deputy sees this conversation taking place, I immediately advised my shift supervisor, Corporal Karen Marlowe, of what inmate Selby had told me. She then contacted Assistant Jail Administrator Dan Burns to inform him of what had taken place. I spoke to him briefly on the phone, and he advised he would contact Akron PD himself. Corporal Marlowe then instructed me to write a brief report of what happened. So, we have two of her and another Portage County deputy subpoenaed to come in to talk about their observations. When I say communications, I don't mean what he said, Judge, with inmate Selby. What they did in response, the fact that they contacted APD in response, I think is relevant to this case. And Mr. Selby saying, yes, I pressed the intercom button. Yes, I wanted to speak to them after I spoke with Mr. Boggs. Yes, I told them what Mr. Boggs said. None of that's hearsay. Is relevant and admissible to this case as a suspect in this case for Mr. Boggs. And then bringing Mr. Boggs in, Judge, to ask him whether or not he confessed and said these things to that inmate is something that we should be able to do.
Do you want to say anything?
Do I need to?
Do you want to respond for the record?
Well, for the record, Judge, I mean, well, the court's already made a ruling without needing me to do it. I wouldn't want to waste anybody's time. So, obviously, Judge, that's hearsay. It's just, it's the appearance of trying to allude to something and let the jury have an impression. Just like if I were to bring somebody in and have them take the Fifth Amendment in front of them to have them believe they're taking the Fifth because they had something inculpatory to say, you know, like maybe the wife comes in, I know there's privilege, but you know what I'm saying, or a brother or somebody comes in to testify and say, you know, you're here because we subpoenaed you in regards to this case, and he takes the Fifth as though he's protecting his brother. And it may not be for that purpose, and you can't do that. You have to do that outside the presence. There's a reason for that. It's because it's trying to give an impression to the jury that is inadmissible and impermissible. And so we absolutely feel this is inappropriate. Just like if we were to say that somebody was talking to Stanley Ford and it looked suspicious, and we brought them in and said, deputies, did so-and-so talk to Mr. Ford and did it look suspicious, and then did he immediately push a button and call APD? it would be, they wouldn't even get close to coming in and testifying in that case, and so we would object to any of that testimony, Judge.
There's a lot of circumstantial evidence involved in it, Judge, the relevance and the time frame in which this happens, the immediate time frame in which it happens with Mr. Boggs talking to Mr. Selby right after he's been confronted by the police. We should be able to ask Mr. Boggs these questions, and we should be able to lay the foundation in front of the jury for why we think it's relevant to ask these questions through what the deputies did. It's in the police investigation, Judge. They chose, not our fault, but they chose not to go out and interview Mr. Selby. So all of that's relevant information. And we talk about circumstantial evidence. This is circumstantial.
Absolutely, that's absolutely not circumstantial evidence of anything. It just, we have people that talk to Mr. Ford all the time, and to put him on the stand to suggest that he's confessing to them is not.
How could we not be able to explore
You can
a
with Mr. Boggs.
suspect in this, through what?
Through Mr. Boggs.
Well, no, Mr. Boggs is most likely gonna come in and take the fifth, so we should be able to tell the jury why we think he's a suspect. Not only what the Akron police chose to do with him, but what was also developed outside of what the Akron police chose to do with him. And the immediacy of what is happening makes it extremely relevant and probative in this case.
Immediacy of 4 years later?
No, the immediacy of him on the very same day he's being questioned, he's being sniffed by a drug or an arson dog, and the fact that his place is being searched, he's being questioned, and to come right over to Portage County Jail and immediately confess, we should be able to ask him if it's true.
You can absolutely ask Mr. Boggs that question. But what will not happen in the order that you want to put it on is that the deputies aren't going to testify, and then you maybe put Mr. Selby on, and then maybe you put Mr. Boggs on. You have to get Mr. Boggs on the stand, and you have to ask him if he made these statements.
And if he denies?
And if he denies them, you can impeach him or ask him, if I were, I don't want to do your job for you, because I know you know how to do it. But I'm going to limit it to is if I told you that Mr. Selby's prepared to come in and say you confessed to him, is he going to be telling the truth? And then whatever his answer is, you're stuck with it. You may not impeach him with extrinsic evidence.
I'm not trying to impeach him.
But if you try to bring in Mr. Selby to say he did say that, that's impeaching with extrinsic evidence.
I wasn't trying to do that, Judge.
And you cannot bring the deputies in to say, but Mr. Selby told me. Now, if you want to ask him, did you get a report from Portage County? Right?
Sure.
And did you investigate that report?
But Judge, with all due respect, I am not going to ask.
But you are implying that whatever he said to Selby, that Selby told to the deputies, is something so nefarious that it's got to go straight to whether or not he's a suspect. You have him on the stand. You get to ask him why he's no longer a suspect.
So Judge, if Mr. Boggs either takes the fifth or completely denies saying it, one of the two.
But I'm going to tell him he can't take the fifth because he's not a suspect.
No,
and
he can take the
well, he can, but then you can grant him immunity.
No, you can grant him immunity.
Well, sure.
But I can't, and I won't even ask for immunity. If he takes the fifth, just like if somebody takes the fifth in any other situation, they have to do it outside the presence of the jury. And if he takes the fifth, it ends right there. Now, I will tell you that they did investigate it, and the problem is he took a polygraph.
The problem is what?
He took a polygraph, and he passed. So we are really in a bind then, because now he's going to say, what?
Yeah.
We cleared him because he took a polygraph. See? And then that puts us in a bind, and it makes it really look.
Yeah, it gets to be a
Judge, we're in a bind because Mr. Lindell's ex-wife refused to take a polygraph. We didn't talk about that either. And she had an attorney call to protect herself. So we didn't get to talk about that either. So that's not even relevant to this conversation because under Ohio law, that polygraph doesn't mean anything evidentiary-wise.
I understand that.
Okay, but again,
that's
why
the
are
answer to
you
this
two
question.
talking to each other?
Because we work things out sometimes.
My
It's not
point
gonna happen
is,
sometimes.
his statement to whomever, Mr. Selby, is hearsay. It's hearsay. It's an out-of-court statement, asserted to prove the truth of the matter. Whether or not you plan on asking it, whether or not you plan on implying that it was said, it is hearsay. It's not coming in. If Mr. Boggs takes the stand, you can question him about what he said, to whom he said it to. if he denies it, then what I can tell you is you could bring the deputy in to say, I saw Mr. Boggs and Mr. Selby talking shortly thereafter around his cell.
And that's what I wanted to do.
Other than that, nothing else.
And-
Not about a report, not about a report turning it over to them, none of it, because that's the hearsay. Her observations, completely different, because you're not impeaching him with any statements. You're showing what she viewed or what she witnessed.
Well, she also received a intercom call, a buzz from the inmate who wanted to speak to her. He appeared very nervous, and he was pointing towards Mr. Selby's...
Mr. Boggs.
I'm sorry, I apologize, Judge, thank you. Mr. Boggs' cell. So she took him out, and she had a conversation with him. I wasn't going to ask her what he said in that conversation.
I know that.
Yeah.
I know you're not going to ask him that.
But that's all
it's
relevant.
no, it may be relevant, but the prejudicial value of that clearly outweighs the relevancy of it because you're implying things without having the testimony already there.
And the problem is, Judge, they can't have it both ways. See, they want to say it's not admissible for me to ask Mr. Selby what he said. I get it, but they can't have it both ways. They can't shut us down both ways. If we're happy to
First
have
of
Mr.
all,
Selby.
no one's shutting you down. I'm ruling on the admissibility of evidence.
I know. But
And so this is how I'm ruling preliminarily.
All right.
It all depends, in my opinion, what Mr. Boggs does when he takes the stand. But I want you to be clear. It's not going to be the deputies, Mr. Selby, and then Mr. Boggs. If you're going to call him, it's got to be Mr. Boggs first before any of those other people testify about what transpired in that jail. And then I'll revisit all of your other concerns and questions. And it really does depend on what Mr. Boggs does when he takes the stand.
Okay.
But in the meantime, we are going to have to find out before the jury comes in what his intentions are. And secondly, I'm going to then instruct him that if he does choose to testify, he cannot say or testify that he took a polygraph.
All right. And for the record, Judge, and I didn't have the name at the top of my head, it was Francine Lewis who was asked to take a polygraph, said she would, refuse to show up, and had her attorney call and say she's not taking the polygraph. So I say...
Is she alive?
Yeah.
Why aren't you subpoenaing her in? Bring her in and ask her, did she kill her ex-husband?
Oh, Judge,
Judge,
there's trial
I
strategy.
understand there's trial strategies, but in the beginning, we went to sidebar and agreed that some of those things were being redacted because they were talking
Yes.
about polygraphs for everybody.
I know, he brought it up this afternoon.
I know, but what he's saying is, Sergeant, no, I want to make sure it's Lieutenant? Oh, Detective. Detective Looney, then, when you cross him and he looks like he didn't do his job because he ruled him out, he's not going to be able to say, I ruled him out because he passed a polygraph.
Well, he ruled him out for inadmissible evidence.
Well, that's exactly what we're asking you to the court to do here. And Judge,
I understand, and I rule.
I know you have.
Somebody could pass a polygraph and still be lying. That's why it's not admissible in our bylaws, but it's stipulated.
No question. Somebody can deny doing something.
But the police can rely on that as an investigative tool, so let's be clear about that.
And Judge, with all
And they
fairness,
have.
they can also rely on an investigative tool when, and we would have loved to have this cross-examination technique with the detectives. When sometimes the detectives ask people to take polygraphs, they do it as an investigative technique, and then they become more of a suspect when they refuse to take the polygraph. And we would have loved to have gone down that road too, but we weren't able.
Well, Stanley refused too, so, I mean, that would open all kinds of doors. So,
Right,
but
which
here's
is
the
why
only-
none of that's coming
Right,
in.
and we've agreed to that, because it's the rule of evidence. One last thing you had mentioned, and I just want to respond to it because that came up and I have not said anything about this. You said that in your mind, the way and you'll revisit it, but I want to put it in the court's mind so that if it comes, you can think about it legally and evidentiarily wise. That if Mr. Boggs comes in and says, I didn't tell him that, you have indicated that you're going to allow the deputy to come in and talk about them, seeing them talk to one another. That's not impeachment of what he told him or didn't tell him. It's only impeachment that they had a conversation.
Right.
If he says, I didn't have a conversation with them, I would agree, but otherwise, if he says, I've talked to him many times, not about that, I've never confessed to him, our position is, and we would ask the court to rule, that that does not impeach him.
Well, the fact that he had a conversation with Mr. Selby would go to this jury's assessment whether they want to believe some, all, or none of what Mr. Boggs responds.
Right.
I know, so.
I mean, it may go to,
Impeachment's not evidence, though.
it may go to an issue other than the actual conversation. It may just go to, listen, it's a fluid scenario. And as again, we're only gonna address this after Mr. Boss testifies.
Fair enough, Judge.
Enough information to make an opinion. Obviously, we've never received that, name of that expert or any opinions that he may or may not have done, or even a letter saying he looked at it and didn't have enough information. I think we're entitled to that. That's, if they have an
Is there
expert.
something in writing somewhere?
We consulted an expert to say, hey, can you even do it? And he said there's not enough stuff here to even make an analysis. He sent it over.
Oops.
And they don't have a right to that. It's nothing exculpatory.
And I don't think we're asking anyone's opinion.
No, let me see these.
There's 3 of them now.
It was 30, whatever it was.
What?
ODRC is also going to need a subpoena for Mr. Bullock to go along with the paperwork.
Okay. So did you get one printed?
He was subpoenaed.
Okay, is that on?
Well, it went to Portage County.
They handed it to him or not.
It's
Well,
filed,
issue a
it's
court,
filed, I can pull it
don't
off
look at
the-
them, just, it could issue a court subpoena and have him brought here, under my subpoena.
Yes,
Yeah, just, right. Just get a subpoena issued, and,
You gonna play those now?
Yeah, she wants to see it.
I can shut off the other monitors if you want, and I can just, it'll just show up on mine.
That would probably be better.
Yeah, there you go. Okay, go ahead.
So is this the one that's marked? Give us numbers.
137, Stacy's at 137.
That's dated to that first video was April 12th, five days before the 2016 fire.
5 or 6.
It's 5 or 6.
I show 412, yeah.
So is that the one that he referred to having? No.
Next, I'm going to play Stacy's at 134.
Oh, this is channel 4. I'm confused.
This is from 719.
Right, I know, but I think why do I feel like I just saw the 6:30-36 a.m.?
You did.
Okay,
You'll see something.
okay, I appreciate that.
And am I fair in saying that that's the one that he referred to as having 2 unknowns?
Don't know, you'd have to ask him.
Yes, I think it is. I'll go back and look at mine.
Excuse me.
That's all right.
And then the last one I'm going to play, Judge, is State's Exhibit 139.
And I'm presuming the person in the blue shirt and jeans is Mr. Ford, even though his face is.
Yeah, and that will be testified to by Detective Looney.
Okay.
I think that, Judge, and I think that is when they brought him into the cruiser on the 18th of May for an interview. Is that right?
Yes. That's all of them.
Mr. Riley? So my question is, you're planning on presenting this through Detective Looney?
Yeah, he'll testify about the known video of Mr. Ford walking to the vehicle, and then we'll play these without any opinion.
Invites for speculation, Judge. There's no foundation, there's no, I just think it is error to allow the jury to guess as to what they're seeing.
So we know the one video is Mr. Ford walking to the cruiser on the 18th of May for an interview. Do we have confirmation from some source that other videos in any way that somebody can say that is Mr. Ford?
They don't, and then the one with the two unknowns, they're trying to tie in those unknowns.
Right. Yeah, they are. I mean,
Based
clearly,
on-
I don't think that's like undisputed that they're not trying to do that. So again, the instructions are that the jury can determine from the facts and the evidence whether or not that is or is not Mr. Ford. I mean, they can determine what credibility and what amount of credence they want to give to that bit of testimony or that bit of video. I get it, but I find that the probative value outweighs the prejudicial effect, and I'm going to allow them to play that with Detective Looney's testimony over the defense's objection. And again, you can renew it before Detective Looney takes a stand tomorrow. All right, well, any other hot button issues? I know you guys want some time to speak with Mr. Ford,
Yes,
right? Okay, so we can do one of two things. Is everyone out of the jury room? Did you clean it? So, deputies, can you take him back there so he can have a conversation with his attorneys, and then we'll see everybody in the morning. I will have a draft of the jury instructions tomorrow.
And this is off the record, the stipulations stuff.